Justice Done Dirt Cheap. It's August 30, 2012 in Fredericton, New Brunswick, Canada. So I wanted to share some thoughts regarding the criminal code section regarding assault, as well as an undertaking. Now, what the criminal code states, and I'm paraphrasing here, I'm not actually reading it, is that anyone who basically physically touches another individual without that individual's consent did commit assault and is charged and is susceptible to the Criminal Code of Canada, which means it can either be a charge that's indictable or summary conviction. Summary conviction is, can't remember quite clearly, it's either 6 months in jail, and indictable is up to 2 years or in jail if found guilty. Now, the other thing is undertaking. The Criminal Code of Canada allows that if someone is in fear of another man or woman, they can petition the courts or pray for relief, which is basically that the other person signs an undertaking to stay away from them, to not go near their place of residence or place of work, and not to have any communication with them whatsoever. So that's the general background regarding criminal code charge of assault and an undertaking. Now, to successfully, well, according to the Criminal Code of Canada, to successfully have an undertaking forced upon someone means that one would have to put their claim down in written form, in the form of a statement. The police would then lay in information, and there's supposed to be a court date set for the person whom is going to have their freedoms restricted by this undertaking, would have an opportunity to argue before the court, present evidence, and respond to the moving party, which is the people who are claiming an undertaking is necessary, would also have to appear at the hearing and give evidence, which means testify, and provide any documentation or other evidence they have to convince a judge that an undertaking is necessary. Now, an undertaking is a severe limitation on one's freedoms. Now, what people don't realize is that if you're unfamiliar with an undertaking, you won't know this, that anytime one breaches an undertaking, which means to go against one of the conditions in the undertaking, that's another criminal code offense that could be 6 months to 2 years in jail. Which means every little condition there, if it's breached by accident or whatever, means that another criminal code charge against the person. So that's the danger of these undertakings, is that the police appear to just go ahead and have others sign these undertakings without the proper consideration and due process. And what it sets up is it makes criminals of the people who would otherwise be innocent of the original allegations. And someone may be facing 2 or 3 breaches of undertakings, which means they're going to be spending up to 2 years in jail, or I mean, it could be up to 3-4 years in jail, depending on the undertaking, depending on the breaches of the undertaking. There's a lot of people in St. John Correctional Facility who are there solely because of breaches of undertakings. Now, the original charges either didn't pan out, or they're found innocent of the original charges, but yet they're spending up to 2 years in St. John for breaches of undertakings. Now, there's something wrong with the process and the system when that's occurring. You shouldn't have jails full of people who all they did was breach a condition of an undertaking, and it's fairly simple. You don't even, it's not necessary to even know you're breaching an undertaking. As soon as the police decide you have, they arrest you for breach of an undertaking. You get held in custody and brought before a judge for a show cause hearing, and the judge decides whether you're going to be remanded into St. John, custody in St. John until the actual hearing of if there's an original charge, be it assault or some other criminal code charge. So once threatened with being incarcerated for 6 to 8 months before they even have a trial, which it's in all likelihood they're going to be proved innocent. They're going to prove their innocence. So this system is not working the way it's set up. It's a lot of innocent people who should be considered innocent until proven guilty, who are actually just remanded to custody and held on all these breaches of undertakings. Now, the undertakings can be simple as if they have a 10 o'clock curfew and they're out at 10:15 because they didn't make it up back in time. That's breach of undertaking. If someone is supposed to be not in a business that serves alcohol and they're in a restaurant that happens to serve alcohol and they just don't know enough about it, that could be a breach of undertaking right there, and it's another criminal code charge. Really simple matters, such as if you're supposed to inform the police of a change of address and you haven't changed your address yet, but the police decide that you did change your address, that's considered a breach of an undertaking, and you could be held in custody for up to 8 months before your hearing, despite you not actually having changed your address. This is the amazing thing. The system works real slow to correct its errors. It's unfortunate, and people spend many months in jail on things that they shouldn't. And just as a note, St. John Jail has about 60% of the population of St. John Jail is from Fredericton. The Fredericton courts just fill that jail. So that's all for today. Just giving the general information regarding Criminal Code of Canada, assault and breach of undertaking, and thank you for listening. The next video I'm going to do is going to be specifically on my issues regarding the frivolous, vexatious, and unfounded claims against me for assault and breach of undertaking. Thank you for watching. This is Justice Dunder, Chief from Fredericton, New Brunswick, Canada.